Hello, everyone. My name is Mehran Fardis. I'm an immigration attorney based in San Diego, California, serving the entire 50 states of US and worldwide. If you have any questions, contact me. Immigration is federal law, so we can assist anyone, anywhere. I'm very passionate about immigration. I'm an immigrant myself, so this is kind of my journey to do this for something that I really enjoy doing. I am giving these guidelines and suggestions based on general and broad categories. These are not specific advice for your unique case. Each case is different. If you have a question about something that we're discussing here, contact me. We can explain to you and see if this fits you or not. Today, we're going to talk about something very, very important that a lot of people miss. This is about family-based petitions. So family-based petitions is the topic of our discussion today. What does that mean? It means a family member applying for another family member to get their status adjusted, meaning requesting a green card. So family-based petitions have different categories. Spouse, children under 21, or child to parent are the immediate relative category. They're called IR1 or CR1 category under immigration rules. That is a category that is considered immediate because there's always visas available for these type of requests. And we're going to get into that in a minute, what that means. The following categories, and I'm going to cite you the specific site to look at these. If you wanted to, you can look at these under the State Department's website, and you can search for Visa Bulletin for April 2023. There's also USCIS sites that reference to these on what they mean. So the second category after immediate relative category is unmarried and sons and daughters of US citizens. So US citizen parent applying for their children who are under 21. That's category F1. Next one is F2A. That is spouses and children of permanent residents. So you have a green card, you're inside US, or your spouse is outside the US, you're inside the US, you're petitioning for your spouse to come into US. You're not in the immediate relative category, even though you're married. A green card holder applying for their spouse is under F2A category. F2B category, which is the next one, unmarried sons and daughters 21 years or older of permanent residents. Green card holder applying for their kids under 21. F3, married sons or daughters of US citizens. F4, brothers and sisters of US citizens. Why this is important? It is important because it really is a key matter where you're applying this type of petitions. Are you inside US and the beneficiary is also inside US? That's one type of process. If you're inside US, the beneficiary, the person receiving the application, the petition, is outside US, that's different. The beneficiary is inside US, but the beneficiary is planning to leave US and still process outside US, that's also different. It's very important to know this because this can cause a lot of problems. For example, you have a green card inside US, you're living in US, and you got married to someone else. You want to apply for your spouse who is inside US. That spouse must be in status when you file your petition for that spouse. If you're a US citizen filing for your spouse is in US, USCIS overlooks the fact of what that person's status is. Your spouse could be out of status, have overstayed visa, potentially have entered US illegally, there's a waiver for that. And you can still petition for that person inside US. That's the only time you can file for someone inside US who is out of status, is marrying someone who is inside US and doesn't have status. Other than that, any other category you're filing for, if the other person is inside US, they have to be in status. What does that mean? I recently had a guy from Spain. He came to US on ESTA, which is a visa waiver. He came to US, he really liked it, and he's like, oh, I want to stay here. My sister is in Tennessee and she wants to apply for me. So I'm like, the sister brother is the category F4. And if you go to USCIS website, you can see the approval time, meaning when you file the I-130 to be approved to establish the relationship, that by itself is about 35 months. What does that mean? It means if your sister applies for you and you're inside US, you must maintain status inside US the entire time. You have to find a way to be in status. For example, you're on ESTA right now. Your ESTA is only 90 days. You're on a B2 visitor that's only good for 6 months. What do you do for the rest of 36 months? You have to change your status or find a way to be in status. You cannot overstay your visa. You cannot become even a day unlawful inside US. So you have to find a way. For example, you can file, if you think you want to study inside US, you can change your status to an F1 student visa and be a student for 3-4 years until your time comes around. USCIS approved the I-130 that your brother or sister filed for you, and then you can start the petition for adjustment of status. It is very important to know that except spouses of US citizens, everyone else must be in status at the time of filing and remain in status the entire time. So brothers, sisters, sons, daughters of anyone who is inside US and is petitioning for adjustment of status has to stay in status. Now, when you file the I-485, you file the I-130, and when it is approved, when the I-485 time comes around, that's the clock that when it starts. So at that time, it's okay to be, your visa ends in 2 weeks, you file I-485 today, and you're okay to be here for 6-7 months past your visa date because the new clock has started. For example, a mother comes into US, actually this is the current case. So mother came to US from Dubai. She came in a visitor visa. Mother's son is a US citizen. So mother has 6 months to be inside US in status. Her son can apply for her, which is what we're doing right now, for mom to become a US resident. While mom is in status, we can file from the son to mother for the mother to become a resident in US. Because immediate family relative allows for concurrent filing I-130 and I-485 at the same time, the mother will be in status while this is getting processed. But if the mother stayed a day longer than her visa duration, 1 day past the 6 months, son can no longer file for mother while mother is inside US. Mother has to leave, and the son can apply for her from outside US. Consular processing, mother has to go to the consulate or embassy where she is and process the visa from there. So it is very important to know the interaction between the parties and where is who. Is the person inside US or outside US? When you're filing for somebody who is outside US, that's generally okay because it goes through the consular processing. That person meets an officer outside US and the visa gets granted at that time. But when the beneficiary is inside US, be very careful about their status and their relationship to you. If they're overstaying their visa and are not in status when the petition time comes around, visa gets rejected, they're probably going to be barred 3 to 10 years outside the US. So this is a complicated process. I hope this was of help to you guys. If you find yourself to be inside US and you want to apply for someone else inside US, contact us. We can help you. This is a complicated process and we're here to answer your questions. Hope this was of help to you guys. Like this video if you enjoyed it, and looking forward to speaking with you very soon.